History of labour laws in Sri Lanka. Let's look at the history of labour laws in Sri Lanka. Different countries invaded our country in the past. The Portuguese, Dutch and the English conquered us. Here we cannot forget about the British. Sri Lankan legal system got polished and modelled through the Colebrook-Cameron reforms which were done in 1833. Therefore, these labour laws and the Labour Acts have been gifted to us by the British. These recommendations were continuously enforced in Sri Lanka even after the British rule. The laws of a country are not merely formed based on these acts. We are aware of the Constitution. What do you mean by Constitution? Previously too we referred to this. The Constitution is the collection of fundamental principles that help to govern the country. The constitutions that we know of may be written or unwritten. In Sri Lanka, we have a written constitution. Similarly, we are a country with a written constitution. The constitution elaborates on the fundamental human rights, the right to join trade unions, and on the right to perform in trade unions. The first Republican Constitution of 1972 includes a chapter on the fundamental rights, although it does not explain the measures that can be taken with regard to violations of human rights. However, the Constitution of 1978 explains as to how action can be taken with regard to human rights violations. These are institutions like the police, the courts, and other institutions for this purpose. Also, the determinations given in the high courts are important when we look for solutions in industrial disputes related to matters which are not covered by the Constitution or the relevant acts. What does it mean? The decisions regarding industrial disputes are taken based on the determinations given in high courts related to similar matters. Such determinations are taken as precedents when the disputes are settled. If we cannot find a solution even from the high court determinations, then we usually move on to legal luminaries. We refer the views expressed and books published by the legal experts. If we are not able to get an answer from these methods, then we'll look upon cultures and traditions. On certain occasions, all these three sources have a very important impact as a part and parcel of law. What do you understand by that? The high court determinations, the views of the legal experts, and cultures and traditions have an important bearing on these matters. Why do we need a labour law? We cannot expect the agreement formed between the worker and the employer here to be equally effective in the case of commercial law. Here there's a significant violation. If we want to make an agreement, we have to consider one basic condition which applies here. It is believed that both the parties should have equal bargaining power in such an instance. This is why we are going to explain you the importance and the need of the labour laws. The employers are a very powerful party. The agreements are drafted by the employer. The workers has no capacity to instruct the employer to delete anything from the agreement. In this situation, the worker has no other alternative plan placing the signature for the agreement, indicating agreement for all the conditions. However, here we have the possibility to change one point. What is that? It's the law of the country. What is the law of the country? It's the Constitution. The Constitution means the set of fundamental principles which are adopted in ruling the country. This law is equally applicable to all the citizens of the country. But if there are different service conditions and if there are acts to cover the required provisions, that would become enforced and prominent there. The service agreement is not that important in such instances. Let us look at a small example. Suppose that a worker makes a written submission to the employer stating that he or she does not need to join the ETF or the EPF, but in spite of this written submission by the worker to the employer, the Act has specifically mentioned that it is the responsibility of the employer to make the 8% contribution of the worker and the 12% contribution of the employer to the fund duly. Similarly, the employer will have to contribute 3% to the ETF. If this responsibility is evaded, the employer will have to pay the 8% on behalf of the worker along with a penalty. This prevents the employer from suppressing the workers according to personal whims and fancies. On behalf of the government, it is the Department of Labour which undertakes the implementation of these laws and acts. The Minister of Labour, the Commissioner of Labour and their representatives have been located all the while to look into these matters. The Department of Labour is vested with the sole authority to implement the laws contained in the Acts as they are. Number 1. Workers get coverage under the Shops and Offices Act as follows: working conditions, overtime payments, working hours, leave, maternity leave, safety of workers. All the matters related to working conditions, overtime payments, working hours, leave, maternity leave and the safety of workers are the facts covered by one single act here. Number 2. The workers who are not covered by the Shops and Office Act: factory workers, salary payments, overtime payments, wages control boards. These are several categories of people who are not covered by the Shops and Office Act. Who are these categories? Factory workers belong to one category. There are separate acts regarding their subjects. For example, we will have to separately utilize different acts in relation to the payment of salaries, overtime leave and wages control boards. Wages Boards Ordinance. This includes and covers the rules and regulation related to the payment of salaries, minimum wages, service conditions, overtime payments and other matters related to the workers working in the private sector, corporate sector, semi-government sector, corporations, board and factories. Here there are 3 factors to be considered. There are certain categories of people who are not covered by this. This act has no relevance to vocational training and to vocational training institutions dealing with the persons with visual, hearing and speech disabilities. Most importantly, the workers who have no relevance to the Shops and Office Act get coverage under this. Let's now look at certain acts which can be generally applied to both the above categories equally. We all know about the Employees Provident Fund Act, Employees Trust Fund Act, Industrial Disputes Act, Workmen's Compensation Ordinance, Gratuity Payments Act, National Minimum Wage Act 2005, Budget Allowance Act, 2016 Budget Allowance Act and the Trade Union Act, Wages Board Act and Factories Ordinance. Actually, even though we have a large number of acts, here we have only indicated 11 acts. Further, all these acts are not relevant to all equally. Some are applicable to some parties and others may not be applicable. Thus, we will get a sound understanding about the basic structure of labor laws only if we possess a basic understanding about these matters. Social space. This is your space. Your protection is your right. Please join with us to reach to the latest information on Socialist Phase. Subscribe us. Press the bell icon too.